SJC-13835, Commonwealth versus Michael A. Diaz Jr.
Okay, Attorney Campbell, good morning.
Good morning. Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. We ask you today to reverse the allowance of the defendant's motion to suppress. The motion judge here erred in two distinct ways. The first, actually, let me go back. The Commonwealth, the motion judge's ruling has two distinct components. The first is a ruling that this cell phone was properly seized as evidence, incident to arrest. The Commonwealth is not challenging that ruling. It is a correct ruling based on the evidence that was presented. It is the second ruling of the judge that we are challenging, which is under White, that the police had an obligation to obtain a search warrant expeditiously and that they took an unreasonable time to obtain the search warrant.
Can I ask you about maybe jumping ahead to the federal cases?
Yeah.
Because obviously the federal cases are the seal and the four for us, right?
Mm-hmm.
As I counted, and I'm sure there are others, there are at least 3 federal cases that say after a search incident to arrest, this reasonableness inquiry applies. So we're talking about White right now and whether White says that. But does it matter if the federal jurisprudence says that there's a reasonableness requirement on a cell phone search incident to arrest?
So I think that there is a reasonableness requirement. I think that's true under the Fourth Amendment. I think that's true under Article 14. I think that's true anytime there's a seizure and anytime that there's a search. I think the question is whether there's a requirement that reasonableness requirement makes the police have to obtain a search warrant expeditiously, as quick as possible in a certain period of time. The Commonwealth is not alleging that there shouldn't be a reasonableness inquiry. I think the test that White uses and the test that the federal cases use all come from United States v. Place, which is a seizure of luggage at an airport case. So I think that test does apply. I think it's the balancing of the test that needs to be sorted out.
So your position is not that just because the cell phone was seized incident to arrest, there is no need to figure out whether the subsequent delay in getting the search warrant to search the contents of the cell phone was reasonable or not. You're
Correct.
conceding that there is this need to perform that analysis.
Yes, I think where the error lies is how that the factors are weighed, and specifically the defendant's possessory interest. And the motion judge, in considering the possessory interest, conflates the possessory right with the privacy right, and there are two distinct rights under the case law. The possessory right under the Fourth Amendment, and as far as I can tell under Article 14, and I don't think there are any cases that say Article 14 offers more protection, is to really addresses the deprivation of individual dominion and control over your body or your property. The privacy right talks about your right to privacy, not to be searched, right? So there are two analytically distinct rights.
But in terms of digital information, I'm not sure that physicality that you're talking about makes sense anymore, because nobody, well, I shouldn't say nobody, but it is incredibly important to individuals. The information on the cell phone is what's important to them, not the actual cell phone itself. It's the information that's in the cell phone, and the deprivation of access to that information seems to me what is the defendant's interest. Not just, I don't have my phone, I don't have the photos on my phone, I don't have, my contact information on my phone, I don't have access to the GPS on my phone, I don't, all of those things is what I think the individual cares about when they don't have their phone.
That may be true, but I think if we're talking about interference with possessory rights, you have to ask, and a proper analysis would look at what that individual's possessory right was in that object. So I think your question is assuming that there is an absolute right to possession to those items. Where there is a proper lawful seizure incident to arrest, it recognizes that that is evidence of the case and that it will be held until trial, and so that possessory interest is not the same.
Wouldn't that rule swallow the reasonable inquiry?
Yeah.
If it's search incident to arrest, and I think it's plain that there was, under the statute, there was a right to take the cell phone. Under your rule, I guess you're positive that there's no possessory right, he ain't getting it back.
Yes.
Then, okay.
Yeah.
Then where do we go for the reasonableness inquiry up until time of trial?
Well, the reasonableness inquiry, I think if you're talking about that right of access to the data, that really is your right of privacy. Because if you're not getting it
I'm
back-
talking about the
No.
cell phone.
No, but if we have a right to properly hold that piece of evidence until trial and the individual is not getting it back, then there is no
But
interference.
if you go to like,
But then you have a categorical rule. You started off by saying that, not what the amici is saying, and that there's no categorical rule that if it's a search incident to arrest, that the reasonableness factors don't apply. You started off by saying they do.
They do.
Okay. But then as a subset to that, you say, well, we look at whatever the evidence is. And if it's a property right, and that property is something that's going to be evidence in the trial, then you do have a categorical rule because you're saying we have no reason whatsoever to go out and do this expeditiously to get a warrant. So what's the point of starting off by saying we don't have a categorical rule?
Because I think, and this is just to counter it, to make sure I understand logically where we're going, if it is properly evidence of a crime and we do get a warrant, whether you get it on day 1 or day 60, if there is evidence related to crime, the individual is not getting it back. So I'm not sure what right we are protecting in ensuring that this search happens within any period of
well, that's the point, though, that the warrant requirement requires. Like under Borellis and some other cases, it says you can seize a cell phone in instant arrest subject to obtain a search warrant, right?
Yes.
If they obtain a search warrant and a magistrate passes on it, they look at the cell phone. If there's no evidence on it, you get it back.
Yes.
By operation of 276.3, right? So
Except unless the actual physical item itself is evidence of the crime, which I would say it is here, where there is a case, and this isn't true in all cases, and I think that's why it's not a categorical rule that just applies to cell phones. I think factually it's important to look at what type of case we're talking about, and I think it's important here that it's both a child rape case in which there is little corroborative evidence. The fact that the defendant even had a cell phone, the fact that he had a cell phone that had a flashlight, that could be in and of itself corroborative of the victim's testimony.
wouldn't that play to, I guess it goes to the strength of that evidence, because if it's a very distinctive cell phone and the person wasn't a family member,
Correct.
right, that would weigh in your favor. But if it's a black iPhone that has a camera and a flashlight in it, so what?
I think, though, if you have sort of any case that is a victim against another person, any evidence that could be corroborative, I think that goes to the weight of the evidence. But I think the Commonwealth isn't deprived the ability to present that evidence at trial just because it happens to be a cell phone.
You get a you get a search warrant. They look at it. There's no evidence of it. The cell phone. The person files a motion for return of property. They take a picture of the cell phone and you get it back.
Certainly. But I would say that, yes, that's true. I would say here, if you're looking at it, though, I think it's important to look at the time in which they did get it, right? So it's not like it's like a week before trial and they get a search warrant to go into this. This is during the pendency of the investigation. It is prior to the defendant being indicted. I would caution that there should be any bright line rule because of the complexities of investigations that occur.
Are you aware of any case approaching over 100 days?
Yes, there is a...
I think there's a 90-day case.
I
saw.
found a case where there's a laptop and it said delay over a year is reasonable.
That was a consent search, though, right?
It's Jarman. It's 61 F Sup 3D 598. It's a 2014 case. There's consent, and then I believe the consent is withdrawn. And so it has to do with what you do when that consent is withdrawn.
Can I ask you just one thing? Because I know this case is closely aligned with the next case. In this case, did the trial judge make a finding as to independent evidentiary value?
She found yes, insofar as she said it was seized incident to arrest. It would necessarily have to be evidence of the underlying crime for that search warrant exception to apply.
No, I mean, what's important to that phone was what was on that phone, right?
See, even if the phone itself, the seizure of the phone, wasn't suppressed.
Well, I don't want to get into what your argument is. I just want to get to what the judge found. And the judge find, independent of the contents of the phone, that the phone itself had independent evidentiary value.
And I would say in finding that it was seized properly, incident to arrest, yes. It would necessarily have to be evidence of the underlying crime.
Can I ask you a hypothetical, just because I want to understand the background law here? Let's say that police come upon a defendant beating someone with a baseball bat, and it's actually like a kind of valuable memorabilia baseball bat, and they arrest him, and they take the bat pursuant to the search and to arrest. They obviously want to use the baseball bat at trial. Pursuant to what case law pursuant to what, does there have to be a warrant ever obtained vis-a-vis the baseball bat?
No.
And why is that?
It's because it's evidence of the underlying crime.
But Section 3 only refers to evidence that keeping evidence for trial that has been obtained as a result of a search warrant.
Correct. I would say Section 1 refers to, and this is almost an inverse argument, it says if it's obtained unlawfully, then it cannot be introduced as evidence. So I would say that supports that. If it's obtained lawfully, it could be introduced as evidence. But there's another case, Commonwealth v. Sacco, SACCO, that says that the same rationale that applies under Section 3 also applies to exceptions to the warrant requirement. So search incident to arrest would fall under that exception.
Not to make a pun, but it's a different ballgame when we're dealing with a cell phone, because our case law says a cell phone equals search warrant.
The contents of the cell phone
Right.
equals search warrant. Yes, and that's where I disagree. And I don't want to sound like I'm talking in circles, but it is difficult. Let's say this is the case and the information that you had is that the defendant had a feather duster when he did these rapes. We wouldn't be having this conversation because it obviously would be evidence that was properly seized incident to arrest. Here, the victims say that he had a cell phone and he used the cell phone both to facilitate and during the commission of these rapes. I say that the physical item itself,
But the Commonwealth starts this, though, because the Commonwealth wants to use, of course, rightfully so, the contents of the cell phone.
yes.
It's not like the baseball bat or the feather duster when in and of itself extrinsically is what you want. You need to have further testing to get the contents, and you need a warrant for such.
You do, but I would say just analogous to, let's say we have a baseball bat and like the case that was just being argued, further testing as it relates to handler DNA. There is no imposition on the government to obtain that handler DNA expeditiously.
But can I go back to the analogy to the baseball bat? So your argument is essentially a baseball bat argument because this is a distinctive looking phone, yes. Correct? And so you're arguing that the police, that there was probable cause, that, this child victim they didn't actually, I think based on this record, say anything about the appearance of the phone. That's not in the record. No. But it is an observably distinctive looking phone that police would think was evidence because they could be helpful evidence in the case if the victims could identify it as the phone that was used.
Correct.
So given that phones are different and contain really important contents, is your view that police should just make their own judgment as to what extent a phone is like a baseball bat in a particular case, and that is just not subject to a review by a court for any reason?
No, I think it is subject to review by a court, and I think that's where the reasonableness aspect comes in. But I also think that
at what stage? Only if a defendant files a motion to suppress?
Yes, I would say it's the same as the collection or the seizure of any evidence in a case.
And what's the standard at that point?
At that point,
what's the standard for how much like a baseball bat the outside of the phone has to be?
I think the standard would be looking at it and deciding whether it is evidence related to the underlying crime, which happens in any case in which there's mere evidence that's collected or evidence that is seized incident.
And I missed this. Did the victims describe the U.S. Army logo or whatever it was in the same interview?
They did not. They did not. But I also, and I see that I only have 30 seconds, I do want to talk about the 120 days as well, because I think that any calculation of reasonableness or any weighing of these factors has to consider that when you have a static item like a cell phone, and it has to be compared to the dynamic realities of police investigations. It has to be compared to their emergencies, which they need to respond to. And I would say that on its face, 120 days sounds like a lot of days, but if we look at the standards with which we govern our own practice of law, there are standards in our rules of appellate procedure that allow for filing a brief within 100 days. There
Is
are
the phone static? Was it like in a Faraday box or something?
it is static. But I would also say
It was?
Yes.
Okay.
Yes, it was properly seized and secured as evidence. So it was.
But that's not the same as limiting access. That was my question.
Off the top of my head, I do not.
Isn't that important? Because other people are continuing to try to reach the defendant. Phone calls are being logged. It's not static. It's a dynamic instrument, unless it's put in some sort of
Faraday bag, yeah.
Faraday bag.
Yes, and I believe in the testimony that the sergeant gave at the motion hearing,
He just said it was seized and secured. He didn't say it was.
he didn't say it was in a Faraday bag. But I would also say if you're looking at possessory right, you should look at what the defendant's possessory right would be to that. If you're arrested and you're in custody and you're in prison, you wouldn't have access.
Was he?
Yeah, that's the issue, because the federal cases that talk about virtually uncertain, virtually non-existent, those are all people who are incarcerated.
Correct.
Here, the record doesn't say, they just say he was arrested.
It does say.
It's your burden, and there was no, because I looked for it and I didn't see any incarceration.
I understand that. I say that that is a factor that when articulating a legal standard could be set. I'd also state that though within the complexity of this investigation, the type of crime it was as borne out through the search warrant affidavit, that the 123 days was not unreasonable given the factual circumstances. And if there are no further questions, I'll rest on my brief. Thank you.
Thank you. Attorney Olson.
Good morning. George Olson on behalf of Mr. Diaz. May it please the court. I would ask that the court affirm the ruling that in this circumstances, the 123 days was unreasonable.
At what point could your client walk into the police station and say, hey, I want my cell phone back?
What was the
At
question?
what point can your client walk into the police station and say, hey, give me my cell phone back?
So he could do that as soon as he was released. He didn't do that in this case. And I would suggest to the court that the fact that a defendant doesn't ask for the phone back doesn't in any way take away from the possessory interest. This is not a situation where my client...
Why not?
Well, this is not a situation where my client consented to the search. He was arrested, they took it from him.
Right, but I think
So
when you're looking at the federal cases, among the factors they articulate is whether or not there was a request for return of property.
in some of them, they do. In the
Why shouldn't we look at that?
Well, so I think that the rule puts the burden on the defendant to ask for it back when...
Well, it's his possessory interest. Why is that unfair?
Well, I think it's unfair because I think it's unrealistic that the police would give it back after it was taken from them in the manner it was taken from them. It's not the situation where the outlined in the unpublished case Williams, where the people actually gave the phone up voluntarily. My client didn't do that. He was arrested. He was taken into custody. His phone was taken. I think it's unrealistic that...
But the federal cases do it. Are you saying that they're unrealistic? It's just a factor. Why isn't that a factor we should consider?
Because I think that there's a myriad of reasons why a defendant wouldn't ask for the phone back. And I think, as outlined in the amicus brief by the ACLU, there's a number of different things. And I think to hold the defendant to that standard in some way lessens the burden on the Commonwealth to justify its seizure. I think that
Can I ask you to pivot to a different point?
Sure.
Which is, so I think the Commonwealth makes this argument that the federal cases upon which White relied in carving out the rule really are about temporary seizures where the evidence may be destroyed in the interim. And so it makes sense to, in that context, talk about how long it took the government to get the search warrant. Whereas this was a seizure incident to arrest. And so as a sort of just as a categorical rule, that's just allowed under Robinson. Why do we treat that exception to the warrant requirement the same as these other temporary seizures, like the luggage at the airport or the house while other people are in it?
Well, I think in the case of a phone, in this situation, even if the police assert that there's probable cause, or even if it's the police do it as a search and to arrest, I think the function here is that for them to make it a priority to get a search warrant, to bring it before a magistrate, to correct an unlawful seizure. And that's the point that White makes.
But it wasn't an unlawful seizure. Let's just say it was a proper seizure incident to arrest.
Well, I think that still there is a value in going before a magistrate to determine whether or not the police are acting correctly. In the
They did ultimately get a search warrant to search the contents of the phone.
Right, but I would
I'm
highlight.
just wondering why we have to test the delay in any way.
Because the person's deprived of
The
a phone
physical
that
phone.
has.
What about the government's the evidentiary value of the phone as it is? It's corroborative of a case where they're going to say both child lied.
So in the motion hearing, there was no evidence produced that this phone had any evidentiary value. The government didn't produce any evidence whatsoever.
Well, I thought that there was testimony that the children testified or reported that the phone was used, or a phone was used during the assaults.
That's right, but there was
And the defendant had the phone.
but there was
The
no
officer used that phone number to contact the defendant.
but there was a finding by the court, and there was no evidence produced that this particular phone was identified by any of the perpetrators. Any of the alleged victims in the case. That this phone, which was distinctive looking, was identified as the phone.
Would it be admissible at trial? Suppose that they didn't have the contents didn't come into evidence, right? Would it be relevant? Would it be admissible at trial? The fact that he had a phone on him.
I certainly think it could be relevant. Relevance is a very low standard, so almost.
Okay, so it is evidence of the crime. If it would certainly come into evidence at trial. So why isn't the phone intrinsically relevant and diminish your client's possessory interest in it? Because the police had the ability to keep it for trial.
So I think that relevance is such a low standard. If they could meet that burden, then certainly it could be introduced. But that would exclude a whole category of phones from any sort of judicial review whatsoever, if that was the standard.
It's just one of the factors we'd have to weigh in the reasonableness inquiry is the possessory interest. It's not determinative, but it's a factor.
Yes, but I would suggest to the court that the contents of the phone are really what the value is of the evidence.
Given the fact that there was a warrant procured to get the evidence, right? What behavior are we trying to curb by saying that this length of time was, not okay, and we're going to not allow the Commonwealth to use it?
So in White, they indicate to correct unlawful seizures and give
But this
somebody
wasn't
back
an
the phone.
unlawful seizure.
Well, that was determined 123 days later after.
No.
They got a warrant, and so it was okay to look.
They got a warrant 4 months later.
To look at the contents.
Right.
But you're conflating two things. The seizure of the phone incident to the arrest was lawful, correct?
Right.
Right. So the police had the ability to hold that phone lawfully. This is different than White.
Right, and in White, it wasn't lawful.
No, I'm not, I understand the point. I wasn't trying to conflate the two. But what I'm saying to the court is what they did in Arthur is what's appropriate. They seized the phone. They went before a magistrate in 3 days and obtained a search warrant to seize the phone. And then waited quite a bit of time after that to get a search warrant to get into the phone. There's no reason why the police couldn't do that in this case.
But the alternatives doesn't seem to me, the idea that there are available alternatives doesn't seem to me like a test for reasonableness under the Constitution. 123 days, I take it you're not advocating for a bright line rule as to a certain number of days and after which it's per se unreasonable, correct? Or are you advocating for a bright line rule?
No.
All right, so what makes 123 days here unreasonable? The police had lawful possession of the phone. There's all this evidence about the diligence, or at least, the judge found that they acted diligently in preparing the materials necessary to seek a search warrant. So what makes it unreasonable? And I don't see any information put forward by the defendant of any harm coming from the delay in this case. I could imagine a case where delay might cause harm, but there's no allegation here of that. So what makes this 123 days unreasonable?
Well, so the court's finding on the diligence was diligence in his employment and his general duties. It wasn't diligence in obtaining the search warrant. In fact, he testified that once he had my client in custody, he placed getting a search warrant on the back burner. So I don't know that prejudice is required.
Okay, so whatever is or is not required, can you tell me what would be the test if it's not a set number of days? Unreasonableness, what is it that makes these 123 days unreasonable?
I think the length of time, the fact that the police could have gotten a search warrant quicker.
But then you're delving into second guessing kind of reasonable investigative priorities that
Police time management.
Right. I mean, are we going to be telling them, okay, prioritize the victim cases, prioritize the sex cases? I mean, we're not going to do that.
I think that given the length of delay, given the lack of urgency to get the warrant in the testimony by the police officer, I think that the Commonwealth had an obligation to get a search warrant to justify at least the seizure quicker than 120 days.
But see, that's where you're conflating the seizure with everything else, not to beat a dead horse, but here I go. I mean, the seizure was lawful.
So
If they had never moved for a search warrant for the phone, what would have been the problematic constitutional event here?
I think that under White, they would have had an obligation to return it, even if they had probable cause.
Sua sponte, without the defendant asking for it?
Well, I think that's what White outlines. Either they get a search warrant diligently, they make it a priority to get a search warrant, or they return it.
In White, it was not a lawful search incident to arrest.
Understood, but there were two holdings in White. The first one was that it was an unlawful search or seizure, but the second one was that they did not make it a priority to get a search warrant.
Here, if it's a lawful seizure, what did the police need to do?
I would say that they need to prepare a search warrant at a minimum.
But let's say they don't want to search. They just want to hold on to it as a piece of physical evidence. They never ever sought, assume for these purposes, they had never sought a search warrant.
So if it's just a piece of physical evidence, and given the importance in cell phones in everyday life, they could just take a photo of it and return the phone.
If requested, I mean, they seize items from defendants constantly.
All the time.
Incident to arrest, sets of keys, a wallet, etc. And if it's important, the defendant says, hey, I want that back. If not, and it's evidence of a crime, it's introduced in trial.
But sometimes they don't give it back. And whether or not, I just think in this situation, when
Have you ever seen a motion for return of seized property? You ever filed one?
I have, I've seen judges not, the police and the prosecutors say, we're going to keep this as evidence, and that's the end of the discussion. More than, in my practice, most of the time, I see the police departments just not give things back, whether or not they have a lawful justification or not.
It's litigated.
Sometimes, but yes. So the expectation that they would return something that they don't need, I think, is not necessarily
But here,
realistic.
there was no motion challenging the constitutionality of the seizure, correct?
There was a motion, but it wasn't argued.
It was argued as a motion directed towards the search of the phone.
Right. The motion was about the
So-
reasonableness.
So I think, in my mind at least, that's the constitutional event that we're looking at, is the search, not the seizure.
Do you disagree with that?
I think the seizure is the delay in obtaining the warrant is the issue, not the actual seizure of the phone. I'm not disputing the lawfulness of the seizure. I didn't do that in the motion here.
I guess I'm still unclear as to what your position is or what your argument is. Okay, so if everyone up here on the bench is beginning with the police properly could seize that phone, and they did, and the issue is the length of time it took them to get a warrant to search the contents of that phone. What is it about the delay, the 121 days to a phone that was properly seized? What is it about that delay that you say, other than it's 121 days, other than you just pointing to the length of time, what about that length of time is constitutionally problematic?
It interferes with his possessory interest in the phone for that length
Okay,
of time.
but that possessory interest never was actualized in the sense of he never walked in and said, I want my phone back.
He did not.
Okay.
Okay.
If there's nothing further,
Thank you.